SJC-13234, Commonwealth versus James Souza.
Okay, Attorney Maidman. Good morning. Hi.
Good morning. If it pleases the court, Stephen Maidman for James Souza. This case is primarily about DNA evidence, and I will address the two issues involving the DNA evidence and then turn my attention to the Commonwealth's chronological timeline. If there's any time remaining, I'll briefly address the sufficiency of the evidence argument. This case is not about the typical DNA evidence, which I'm sure you're all familiar with, where it comes back with expectant frequencies of 1 in sextillion occurrences. This is about YSTR DNA, and it's complex, but it can be simplified. The focus is on the male chromosome, the Y chromosome. So my son has my Y chromosome, I have my father's chromosome, and my entire family line going, my entire paternal line going back to the cavemen have my Y chromosome.
Can I ask you on our case law, because as I read this, I'm reminded of the early days of DNA, where the statistical significance of databases were litigated. And I remember looking at the databases and being shockingly surprised at how small they were and how they're able to extrapolate based upon a few thousand people, basically. And the argument back in those days used to be, we need a localized database similar to this, where he's saying it's the Portuguese community in Fall River, so it's not representative. I just seem to recall that this argument was raised way back when.
I don't remember that in the autosomal DNA cases.
Oh, you don't?
And in this case, it wasn't relevant, so I didn't focus on it. They used the autosomal DNA, traditional DNA, to prove that her DNA was on various things.
I remember litigating this issue on statistical richness of the databases and whether or not they should be localized. And it was okay, at least for, and as you said, the results that lead into bazillions, right?
We have national databases for autosomal DNA.
But this is a national database, too.
Well, it's a very interesting national database, which is what this case is all about. There is a national database. Most people aren't in the database. They use statistics, which I can't remember from my statistics courses on how to extrapolate to what it should be on a national basis.
Good thing we have a scientist on the panel.
Yes, no, yes, that's right.
You know it ain't me.
It's not me either, and that's an issue in the case. But in any event, this case involved his Portuguese background, and family was in basically southeastern Massachusetts. They all lived there for years. They all had children. And it created what the defendant's expert called a discrete population substructure.
Right. I remember the same argument used to be raised about Cape Verdean folks in the YSTR.
Right, but the Cape Verdeans all over America. Right. This is one focused on him, and also that was not YSTR DNA. Those cases, those were autosomal DNA cases.
I misspoke. The regular STRs.
Right, they're regular DNA. So in this case, he had an expert which said, well, he didn't disagree with the numbers. You could literally go on the internet and plug in numbers. He disagreed. He said it's the wrong database. He didn't know whether the number would be higher. He didn't know whether the number would be lower in terms of expectant frequencies.
And Judge McGuire hears all this and says, we'll let the jury decide, and then they don't call the witness.
Well, and that's on the record why he didn't call it. That was a strategic decision on his part. And quite frankly, given you can see the glazed over eyes on DNA, I don't think that was off the wall. But it certainly was fully developed in the hearing about the population substrates and everything else. And this issue has come up elsewhere. This is not something that was unique to southeastern Massachusetts. And I cite the cases, the two, what I thought were the two leading cases in my brief, involving Indian tribes, where they argue that it was a population, it was a unique population substrate of this particular tribe, as opposed to all the Indians in America, all the Native Americans in America. And then there's the other case, probably the leading case is the Commonwealth of Northern Mariana Islands, where the argument was, well, the government was using the mainland USA database as opposed to anything in island in the South Pacific. And there are other cases too, but those are the leading cases, and they were excluded. It's an issue, it's a known issue with YSTR evidence, and that's what the defendant's expert testified to. And to try to answer your question, yes, the jury heard all this. Right. The jury, actually the jury did not hear this. The judge heard this, okay? But the judge instructed the jury to say, look, this is not the same as 1 in 10 sextillions.
You got 1 in 1,300.
Yes, that's fair, and this is not in the record, but you can take judicial notice of the size of Gillette Stadium. Or Fenway Park, and so if you run these numbers through there, you're going to get
Did Murphy argue that in the?
No, he didn't.
Case?
I thought of this.
No. But as far as did he argue? Well, what does 1 in 13 really mean?
I don't remember whether he really focused on that part. I just don't remember because there were other things that happened with the DNA evidence that we haven't gotten to yet. But you read the numbers. He's got 47 of his closest relatives in Gillette Stadium. Now, admittedly, that is not it's not a perfect analogy, but it makes a point. Okay, because it's not a random Pats fans are not all male, and they're not a random distribution of America. But that is the issue in this case. This was southeastern Massachusetts. This is not and it's clear his family was there. Okay, and they took all sorts of about his 18 relatives and everything, 18 male relatives, and so it is an issue, and the judge let it in. With instructions, but in terms of you get into the issue, should he have lit it in the first place because of the population substructure? But as I'm sure all of you have heard on one time, either as prosecutors or defense lawyers, when the jury hears it's consistent, the prejudice is done. Okay, it's consistent. And hopefully it's not, they're not going to say it's him.
Didn't we say in Lally that so long as there is a disclosure of the limitations of this particular type of STRY DNA analysis, that it's permissible? That's what the court said. Okay, and so I guess I'm wondering, in light of that legal ruling, why we would say that Judge McQuire committed an error in allowing this in, that he abused his discretion.
I think the argument is that the focus was on the population substructure.
Right. Was there any information brought forward as to the haplotype for these Portuguese southeastern Massachusetts?
I'm sorry, the what of the Portuguese?
The haplotype. That was sort of
they didn't go
that in the Native American case that you referred to. There was substantial evidence about the uniqueness of that, and here I didn't see any.
I don't think they did. And the Commonwealth's expert who did testify at that hearing got up and said, "Well, I didn't know he was Portuguese."
And actually, in Lally, I thought we had said that it would be better to use the confidence interval, but the counting was okay. And in here, they did use the confidence interval.
They used the confidence. They used the confidence.
So they did more than what was required, what we said was required in Lally.
Again, the issue was the population substructure.
That's a yes. That's a yes to my question, right?
I'm sorry, I didn't hear.
They did more than what we said in Lally.
Arguably.
Okay.
Arguably. But again, it boils down to, did they use the right database? That's what this case is all about. That's what the cases are about nationally, and that's certainly what the defendant relied upon. Let me turn to the next DNA issue, and that involves the substitute DNA expert. The judge saw this coming. That's one thing that's clear from the transcript. He saw this coming. The substitute expert got up there, and she started, actually, the first thing she did is she used the original expert's chart. And she goes, well, it was her chart, but I would have written the same chart. Words close, it was close to that. And then she got up and gave the expected frequency statistic, which, by the way, was different than the other one. It's slightly off.
She plugs in the numbers herself. Second expert.
It's not, it is that. Let me read you the 4 lines of the transcript, okay? Because this is what set off the whole thing. And it's on, just so you know, it's on pages 153, 154 of volume 7. But it's 4 lines. It goes, and this is on cross-examination. I mean, she got up on direct exam and said she intoned the right words. I've reviewed the evidence, and it's consistent with the defendant. She didn't go into that's where she went, and then she goes with the statistic. So on cross-examination, the defense lawyer goes, but as far as that 1 in 137, you didn't do the math. She goes, that's correct. And the next, I think the defense counsel, the record, one can infer from the record that that the defense counsel was rather stunned. He goes, so the information that you used to give that number was not of your own making. It was information that you obtained from Ms. Castor. And she goes, that's right. And this is where this issue comes from.
And Ms. Castor obtained it by entering information into a computer program?
Well, she must have at some point, yes.
So the flaw here is that there was no witness to testify as to what the computer program does to calculate the statistics? That's the Commonwealth's argument.
Yeah,
so can you address that?
And there's a case that says that merely putting the stuff into the computer and
okay, so what more did the original analyst do that you were not able to cross-examine on beyond the entry of the computer program?
Let me back up, since I'm not sure that's the right focus. The cases, all the medical examiner cases, and this is based on Nardi. There's a whole line of these cases, and they say, essentially, you can give your independent opinion, okay, but you can't go into you can't read off the original report, okay. You can't. You gotta. You can say, I reviewed everything, and and in my professional judgment, the profile's consistent with the family, with the defendant, okay? But she went beyond that. That's as far as she could go under the case law, as I understand it. She went in and started giving the numbers. And where'd she get the numbers? She got them from the original analyst.
That's my question. Did she get it from the original analyst, or did the analyst get that from the computer program?
I think she got my reading of the case, and certainly the defense counsel's reading of the case was she got them from the original analyst.
It's not admissible without the numbers.
On direct or cross?
Either on direct. I mean, the DNA testimony is not admissible
Right,
without,
but she said,
without
but
the
she
numbers on the Matai, right?
But she can't. She cannot give those numbers. She can, unless she personally ran the numbers, and she said right here she didn't. Okay,
But
she can't do that.
Does she have to personally run the numbers if it's somebody entering it into a computer program?
I would certainly think so. Those are the details.
No, what
of
is the law beyond what you think?
I
wonder if what is your view of what is the law?
My view of the law,
that somebody who uses a computer program to get the statistical significance, a second person can't rely on that same computer program to generate the right statistical significance. Is that the law?
my view of the law is that the substitute DNA analyst she cannot testify to the numbers that the original one came up with.
Even
if
if
it went
the
into-
original one came up with the numbers using the program?
Sure.
Okay. And what is your best, what's the best law for that?
Yeah, unfortunately, I can't cite you a case at the moment on that, but
Well,
that's
that
certainly.
seems important. I'll look at your brief.
But I thought we had the common law confrontation clause case. Is it Williams? I forget the name of the case. But we talked about whether or not the second expert is cross-examinable. Basically, is it a knowledgeable witness who can be cross-examined? That's where the defendant's rights come in.
Well, that's
correct?
certainly the confrontation clause I read, and
Right, and the confrontation
and that's
clause.
the Supreme Court case.
Yes, both come in Williams in all those
Right,
cases.
but,
And it's our gloss on those cases.
well, they certainly cross-examine. They certainly cross.
So she worked at the lab. She's capable of being cross-examined. So like, to Justice Wendland's point, if the first witness plugged something into a calculator, right, and did simple arithmetic using a calculator, your testimony is the second witness has to put it into the same calculator?
If she's going to, she can, let me restate that. She cannot reveal on direct. That's for the defense counsel to bring up, the details. And compare it with, even all the medical.
But it wasn't revealed on, well, no, I'm sorry, you're right. The 1300 was revealed on direct.
Yes, that's what triggered this whole thing. And the record certainly suggests that.
So to put a fine point on it, your issue is with the testimony of the substitute DNA expert testifying to the frequency numbers.
On direct.
On direct.
Right.
Okay.
And that's what defense counsel objected to. That's what this issue is all about. And I would suggest under all the case law, that was for defense counsel if he wanted to bring it out. And that's certainly what's in the record. Okay, in my last few minutes here, let me address the chronological timeline of the evidence. What the Commonwealth did is they got the lead trooper to put on a PowerPoint presentation of 70 slides, maybe around 70 slides, and that presentation was all of evidence that had been previously admitted. It was maps of cell phone towers. It was still images from video. It was from a variety of different sources, and all that was previously admitted. And so the Commonwealth essentially gave a pre-closing closing argument, and it was good. And with all due respect to my colleague, it may have been better than the closing argument given by the Commonwealth. This was really good.
Would be based on the facts.
Oh, it was the fact. It was the admitted evidence. But the worst part of it, the pernicious part of it, the judge let it made it an exhibit, and the jurors took it into the jury room. So they had in the jury room the outline of the Commonwealth's case. And that shouldn't have happened. And this is going to happen again. You're going to see this. You're going to see this repeatedly, given all the video evidence that's available.
We had this issue in Bookman. It might have been the same prosecutor, but so if someone's prosecuting a bank larceny or some type of fraudulent scheme case, right, and they put in all the records of bank records,
right,
and then they have a chart that summarizes them all and puts a nice bow on it chronologically. Your testimony is that can only be a chalk, it can't be an exhibit.
Well, it certainly should.
Your testimony, your position is.
Yeah, that's certainly my position.
You're-
Okay, that's certainly a position, but it's more than that. This is not a situation where they were summarizing 10,000 pages of cell phone records. This was a video presentation of the Commonwealth's case from this cell phone tower to this cell phone tower, and now we have at the Walmart parking lot, and now we have the car driving down the street. I mean, this was pretty. It was good. I mean, it was a good presentation. I give the Commonwealth credit for putting something like this together. But
Objected to, I'm sorry.
there's objections all over the place on this. But nonetheless, let me one last point on this one. The Commonwealth mentioned somewhere in their brief that I didn't raise a due process argument. This is Wardius versus Oregon, which is a due process case. Okay, it talks about the delicate balance between the defense and the prosecution. Okay? Here you have the Commonwealth giving up free closing argument. And that, yeah, this threw the balance off. It was unfair, and the worst part, obviously, was from the defense point of view, was it went into the jury room. And unless any question about that, let me
Wait, I'm sorry, so you're saying it was okay, or it was not okay as a chalk? Was it okay as a chalk?
Was it okay as a chalk? I would argue that I would argue, chalk meaning going into exhibit?
Not going into the jury room, meaning just
Just the presentation itself?
exactly.
No. It wasn't okay as a chalk because what it was is it was completely cumulative. Completely cumulative. This was put together.
Bank record thing is okay.
Sure, if you got 10,000 pages of bank records and you have one or two slides saying it, sure, that's fine. That's what this is all about.
What's the rule that we make, that you can do a summary as long as it's not a good one? Or what's the?
Summary is if you got large voluminous records. This was not large voluminous
Okay,
records.
but if the Commonwealth introduces 5 minutes of a clip at the liquor store and a 5-minute clip at the dentist office and a 5-minute clip of the, ATM video, right? And they don't want the jury to have to toggle through.
No, they have them. They had them. They had all this stuff. They
Right,
had
that's what I mean, but they want one video that shows everything as a cut-up as opposed to the 5-minute, that it's going to take a jury 6 hours to go through, which they won't do.
They certainly wanted that in this case.
Of course they did, that's why they put it in.
That's why they put it together.
Right.
But it was they gave their closing argument right there. One or 2 minutes on one other thing, with your permission.
Well, it depends. I mean, I don't know if you answered the question. The
Oh,
question,
I'm
the
sorry,
question
try
was
again.
I'm all set.
Oh, okay.
I'm all set.
Just very briefly on sufficiency of the evidence.
very, very.
Very briefly. Pill bottles and telephones. The pill bottles were found in the jacket. Okay, this guy was a frequent customer of the drug dealer, of the victim. Okay, the jury had no clue whether they were taken from the home, not taken from the home. They did have her name on it. There were no fingerprints, so they did essentially come from her somehow. But she sold the guy drugs constantly. I mean, it was overwhelming evidence of that. Finally, the cell phones. Yeah, and by the way, there's no evidence of what was in the. This was portrayed as an armed robbery. There was no evidence of what was supposedly in the cash box before this incident. Finally, the cell phones. The evidence is that, or at least the testimony was, cell phones were bouncing off a cell tower south of Taunton, the Commonwealth wants to draw inference. Well, how'd they get there? That kind of thing. No evidence. He took them. And with that, unless you have any questions.
Okay, thank you.
Yep.
Attorney Stern.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. I guess to start with the Confrontation Clause issue, my understanding from the testimony, I don't know exactly who said what about this at which point, but essentially with the frequency, you have this website that at that point was the USYSTR website. It's actually since migrated to another website with even more profiles, according to the SWGDAM facts on their website. But it has essentially drop-downs for each of the locations of the particular alleles, and you fill in the numbers from the profile that you have, and it will then spit out a number of 1 or 0 and whatever. And the substitute in this case essentially said that, I guess this had generated a printout that showed that what had been entered and what had come out of this program, and she looked at it and said the data went incorrectly, and here's the number that came out.
She didn't do it herself.
She didn't do it herself. Defense counsel had actually elicited, I think multiple times from the other expert who was testifying on her own behalf about other DNA, that this didn't, you plug numbers into the computer. You didn't do anything experty on this information. This is just what the computer gave you.
First expert gets the gets the Y chromosome.
She does the whole
alleles,
thing.
And she plugs it, and she looks at the website, and she gets the 1,300.
Yes, essentially. And
then second substitute expert looks at the paperwork
yeah.
and says, looks good to me.
Well, actually, it's a little confusing. So you have Elizabeth Duval, who tests the lockbox, who does all of that. Then you have Sheila Castor, who does the jacket, who does all of that. And then you have the substitute analyst who looks at her printout and says, I see that these numbers were entered correctly, and this is what the computer gave. And she did do the math she did additional math on a calculator. But she didn't actually enter the numbers into the website again and click enter to see what she got, which might not have been identical because I think a number of people testified. I don't know if this was the motion hearing or the jury. As they add profiles, things change a little bit. The defense expert said at the pretrial motion in limine hearing, he ran these too and got the same general numbers. So he did it himself. That essentially it's plugging the data into a website. And so I think
How does that align with our medical examiner, Nardi type cases? Because I know, we allow a substitute medical examiner to look at the notes and the photographs and to get on the witness stand and say, cause of death was blunt force trauma.
Yeah.
Say no more. And then if the defense attorney says, well, and then, right? How does this align with the Nardi cases?
Well, I think that with this, as I recall with the Nardi cases, that the idea is there is judgment involved even in the fact-looking things that the original medical expert did. The substitute can look at actual photographs and go from that, but even if somebody measures something, you don't know what sort of.
So your position is the Nardi. This aligns with Nardi because in Nardi we allowed the substitute to say the cause of death was blunt force trauma as the bottom line, and here the substitute DNA expert said the bottom line is there was a match and the statistical significance is 1 in the 1,300.
Well, I think that's one thing, but I think also the fact that the computer is essentially doing everything here on this particular step. If in terms of the sort of the lack of human involvement, which again, defense counsel himself emphasized it at other points when he was making other points, that this is just, and so that's what I thought that Cole was relevant to the fact that essentially this part of the process is not really being done by the expert. It's being used by the expert as a tool, but the expert is not actually doing their expert thing except by knowing which computer program to go to, which is their own information that essentially, if we didn't have the evidence that the correct alleles were entered, I suppose that would be different. If she hadn't, if she looked at the result, my understanding from her testimony was that the computer printout generated by the original tester was these were entered and this came out. If she didn't have that these were entered, I think she would have to do it again. You could even say in the future she should do it again. I just don't think that there's much as a practical matter. Maybe she didn't do it because it would be a slightly different number. I don't know. Certainly she was willing to redo the calculator math on her own, but that essentially, for the reasons that this court has said, that the stuff the computer does on this is not testimonial and not hearsay, that would be true of a substitute experts using that data as well in this very particular circumstance. Now, what Smith versus Arizona will say, I don't know, but none of us do. But so I think that that's essentially the very narrow thing that was under discussion here on that issue. And the judge was very, there was motions in limine to bring in the substitute expert. The judge was watching this issue very carefully. He thought about it. He said, because you have the confrontation clause issue and you have the Marquardt issue. He said, that the expert can't testify to the underlying data on direct when they're a substitute. The question is, what is the data? And I think it's the alleles. I don't think it's what the computer did. So he essentially, I think, went through all of that analysis quite reasonably. And again, this was highly, she was the testimony about this particular evidence, but, this profile was derived from two different pieces of evidence. The defense expert himself agreed it was the defendant or one of his male relatives. The defense counsel knew his expert had rerun these calculations himself and agreed with them. So in that sense, he was entirely entitled to stand on his rights, but he didn't have any reason to think that there was anything there he was going to find on that particular issue.
What about the issue of the wrong database?
Yes, so I think that's, so very, very zealous defense counsel in this case, and I think that but objected early, objected often. Overarching, a lot of his objections are, this is hard, it requires nuance, there's context, so the jury shouldn't hear it at all. There's no way to make this safe for the jury. And the judge, I think, consistently was saying, we will give the jury all the context. The jury will understand the context, and we can trust the jury to use the context. So the judge, that there was this motion in limine, which the judge heard from both sides' experts. I think the showing on whether there even was a population substructure here, I think, was not as strong as certainly in the cases the defendant cites, as in Donick, about whether being Portuguese in southeastern Massachusetts really would raise this issue. But regardless, I mean, the defense's position was, you need a local database. There is no local database. The jury can't hear about any of this YSTR.
It was Dr. Lakin?
Sorry, yes.
Did he investigate or say anything other than the fact that Mr. Souza is Portuguese? Did he say?
I don't recall. I mean, he said that he has
interbreed and et cetera?
No, Your Honor. I mean, he has family in the area. That was in evidence, though some of them were kids and some of them were dead. But, I mean, certainly there is a large Portuguese population in southeastern Massachusetts, but what that means for this.
Right, so it wasn't like the discrete Native American tribe.
No, or even like the Ashkenazi Jewish population, as far as we know from the evidence, and Portuguese from Portugal. Essentially just that you can trace it back to the great-grandfather or whatever, and they've been in this area since then. Though they Fall River, not Taunton, whatever that would mean in this case. But, as I cited to Lally and also to Donick, that this is all, the issue is that the jury have the context for both, for the DNA in general, but also the DNA in the context of this case. That, the counting measure was good enough in Lally. Things have gotten more and more precise as we get more data, as things, the defense was able to ask, if you applied a higher confidence interval, what would you get differently if you apply, if he got various experts to agree, maybe it's 1 in 500, maybe that's.
We didn't require a confidence interval in Lally.
No.
And here we had.
Yeah. I mean, so the takeaway, I think, from the totality of the case law is that the jury needs to have some understanding that this isn't definitive proof of guilt, which it pretty much never will be for YSTR. You need a very strange, unusual fact set. I'm not saying it would never happen, but, they're always going to be in the thousands and not in the quintillions. And the judge actually went out of his way here to give a sua sponte jury instruction that, you make sure not to confuse YSTR with STR for. Because
there was STR in the case.
There was STR in the case, and the STR was in those numbers. Now, certainly, we have admitted very marginal STR evidence and trusted the jury with that for a long time. So, much lower numbers than this. So YSTR has the fact that it's specifically not just a, 1 in 3 or 1 in 1,300, but that, it could be the defendant or any of his paternal male relatives. But as the prosecutor said in his closing, and then look at the evidence. Is there anybody else that this is likely to belong to who was involved in this case? And this case was, and I guess this arguably ties into the compilation argument, but it was made of lots and lots of small pieces of independent data, which made it very robust against issues with any particular one of those. But it was, of the ways that we know that the defendant was in the area of the murder at the time of the murder, there's CSLI, his car's on surveillance footage at 3 different, at least, places. He's on surveillance footage nearby at a gas station, going in with his hands covered right afterwards. He's texting with the victim.
But what about this timeline overkill?
Yeah.
Can you address that issue?
Yes. So, I mean, as I said, the defendant, because defense counsel is very zealous with his objections, they weren't specifically focused on this. They probably cover this. I mean, he had some specifically about this. It was the, not the lead detective, but essentially the Commonwealth's forensic expert. So he dealt with a lot of, the defendant's most vociferous objections were to merging the phone records so that you could see them in chronological order. That was where he had the discussion about Commonwealth versus Wood with the judge. He really didn't, he thought the jury should figure that out for themselves. They shouldn't get to see that in a timeline as Exhibit 150, which I think is not an issue on appeal. So he was objecting to all of the phone records. And
So let's just assume it was preserved.
Yes, I am.
How is this, appropriate to be using
Yeah.
with a witness as opposed
Yeah.
to something that is a chalk that
Yeah.
doesn't go to the jury in closing argument.
So, so one thing I was heading towards there is that this witness actually personally was the witness through which a lot of this evidence came in, because, he corrected the timestamps on all of the videos based on his personal having gone there and his knowledge of DVR. So that came, the surveillance video came in ultimately as exhibits through him. The phone records came in through him. The CSLI came in through him. So he is the person who essentially gives the context for all of this evidence in his own testimony. Not everything, but most of it. The presentation itself, since this case, we've brought these presentations in by motion in limine where it can be hatched out in a cleaner way. So there will probably be better records in other cases on that. But it's a lot of it, it puts, the basic thing it does is it puts the phone data in time where you have cell towers. I would argue it's actually pretty dry for that purpose. Looking at it, it's hard to it's not exciting for the most part. There's differences, but, and he doesn't, it talks about what, like it says up at the top, BC to JS text message, but it doesn't say what. It doesn't sort of get into any of the sort of critical sort of what conversation they're having that morning. You can see the defendant's phone moving up Route 24, and then he does have some stills of the videos that ultimately he was the one who gave the evidence of when the time on the video was of, the defendant's phone is here, the defendant's car is here.
Can you address what our case law is on this and whether or not this exceeds it or is compliant with our case law? On this
I think
type of evidence?
our case law is probably still evolving on this. There's Wood, which is very thoughtful decision, but doesn't, it's crossing the line from presentation of evidence into argument, and that is inherently a somewhat subjective thing that was not squarely, I think, discussed in this. In this case, I think I would argue the Commonwealth had a clear right to get in. And the judge said, the jury's going to have trouble interpreting the locations of the towers without a map. The timing of the phone calls relative to each other, essentially how all of these different sort of tiles in the mosaic do fit together into the picture. I think the trooper his testimony may have suggested he initially did this so he could see it. That where you have cases like this, which I think are within permissible boundaries to be encouraged, having these mosaic of evidence cases, because they're much less like they're squarely aimed ultimately at our strongest objectives of identifying who did do it and identifying who didn't do it. You're much less likely, it doesn't pose the same risks as a single eyewitness identification that, in 40 years we're going to be, that having all of these, being able to bring all of these discrete pieces of different types of evidence together to all show one person is something that we really want to be able to use for the sake of justice. Obviously, you don't want to have, and the judge actually said, the defense can excerpt anything they want from the evidence. There's no inherent Commonwealth prerogative here, but that certainly it should be, and I don't think anything says it can't be possible to just put together in order what all of the different the phone records and the keepers of the records from all the different gas stations and all of the different, the DNA was not on the compilation at all. The photo of the pill bottle, I don't know what that adds in this case. I don't think it caused any prejudice because the jury was not going to forget about that. But just in terms of, you heard all of these different people talking about all of these different things. And again, many of them ultimately with crucial contributions by this witness that the jury didn't have till he testified. That here is how this evidence in its most fundamental way fits together. He didn't say, he was very careful, and defense counsel was very on top of, you can see a person here. He doesn't say you can see the defendant. It's, you see a person in the woods in the corner of this photograph. You see, and it was very carefully kept on what was actually in the information that was actually the evidence. So in some sense, some of it he said it twice, but I think that the prosecutor's closing, which frankly I thought was excellent, included a lot more information and a lot more discussion of other things and discussions of other potential, I think other potential third-party culprits. But again, the DNA wasn't in this compilation. So you know, there's a lot of, I mean, it's easy to say there's a lot of interesting things that could have been in the compilation that weren't, which is neither here nor there. But I think that essentially a fairly dry organization of the evidence to show the picture that the individual pieces do in fact straightforwardly show is a very valuable tool, and obviously you don't want that to be abused. But I think that it's important to, wherever, as the law evolves on a case-by-case basis here, to maintain an appropriate version of that as an option for all the reasons.
Looking back on it, would you, if it were, you know, if you had it to do over again, is that something that would be, that a prosecutor would ask to have sent into the jury room?
I don't know. I mean, certainly in this case, we actually discovered the jury couldn't play it because it required internet. They did ultimately get the information. That issue was not discussed. I don't know that they couldn't send it into the jury room, but I think that you could certainly, you could set that boundary. It's, you know, yeah, I don't have a, certainly you could say it would have to be a chalk in the future. I think there's some basis in the rules of evidence for making it an exhibit when it's actually appropriately just a synthesis of the dry facts, but putting them all together. But yeah. If there are no further questions,
Okay.
Commonwealth rests on its brief. Thank you.